Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Finley. Mr. Finley, please state your name for the record.
Aaron Finley.
Your Honor, today is the date and time set for final settlement conference. I have had a conversation with Ms. Barroso, and I suppose the plan is to dismiss the misdemeanor as it's been reauthorized as a felony.
I do believe that you have the felony file in front of you, and I would be asking that you arrange on that today.
All right. Your name, sir?
Aaron Finley.
Finley? You are before the court. It's my complaint here. Is there a reason why it wasn't printed out? You are before the court on a complaint that alleges that on or about December 1st, 2023, location of 3127 Scenic Lake Drive, Pittsfield Township, Washington County, State of Michigan. Count one alleges that on that date and at that location that you did assault with the intent to do great bodily harm, less than murder by strangulation, the individual known as Lindsay Forbes. You understand that charge, sir? Do you understand that charge? Yes. You're going to verbalize for me?
Just need to speak up.
Yes.
That is a felony. It is punishable by up to 10 years incarceration and a $5,000 fine plus court costs. Would require your DNA be taken upon your arrest. A consecutive sentence is possible under statute if the assault took place in a place of confinement. You understand the maximum penalty, sir?
Yes.
Count two on that complaint alleges that on that same date and at that same location, you did interfere with electronic communication causing injury or death. Causing injury or death. You understand that, sir?
Yes.
That's a felony, punishable by up to 4 years incarceration and a $5,000 fine plus court costs. You understand that?
Yes.
Count three on the complaint alleges that on that same date and at that same location, that you did commit the offense of domestic violence upon Lindsay Forbes. You understand that, sir?
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs, and could be subject to a consecutive sentence. You understand that?
Yes.
First question I have for you is, do you want to be represented by counsel? Public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Finley.
I need eight.
We waive any further reading and stand mute to the charges, Your Honor.
Send in every way form of reading, standing mute. Court will enter a not guilty plea. Court will set this for probable cause conference. You're demanding that, is that correct?
Yes, Your Honor.
We'll set it for probable cause conference on the 20th, 2024 at 9 a.m. And then a preliminary examination would follow from there. As to bond.
Your Honor, we are asking for bond to continue the same bond as the misdemeanor file. Mr. Finley has been on bond for quite some time. He has had no violations. In fact, he lives on Flint, so he does live away from the complaining witness. He has had no contact with her. He's been compliant with the court's orders. He's been here for every court date. Bond is working as it should be. He has significant family support. His grandmother is here with him. His sister, he lives with his sister. She is also his guardian. And I've had multiple conversations with her. I know that she's very involved and ensures that he gets to court and does what he needs to do. He does have another case in Oakland County that's scheduled for pretrial on Tuesday.
And the case is
And the plan there is there has been an agreement that file is going to be resolved on Tuesday. And then I don't know what the resolution is, but
on a CSC, what degree?
Most of the degrees have been taken down. It's just a third degree right now.
It's a third degree. Okay, go ahead, miss.
he has been out on bond in that case. Obviously, Your Honor, he is with us. And again, there has been a resolution in that file.
Does that CSC involve the same person in this case?
No.
All right. From the people.
I do not rely on interfering with communications was not authorized at the outset, but immediately upon review of this file, I've submitted a request to have this reauthorized as a felony. I do not believe that the bond that is currently set is appropriate in a case to this degree. However, I understand that the defendant has been out and has been compliant. To the best of my knowledge, I will say I don't know when the allegations in the CSC occurred, if that was after the initiation of this case, or if that was prior to the initiation of this case. But at this point, I will be.
When did the CSC, when did,
He's indicating that he was first arraigned in 2022 on that case, so it's an older case. I don't have the date of offense
But-
with me.
okay. But the problem is that he was on bond on that case when this case comes up. To your knowledge, was that addressed by the magistrate upon arraignment and the other matter?
If you give me one moment, Your Honor, I can check our notes. No, Your Honor, because there was no indication whatsoever that that case was ongoing and he has no convictions on his record. So my understanding is that we did not note that in our bond form. So it would not have been necessarily to be argued by the APA.
He's residing in that the Flynn address.
Correct.
All right. I'm going to indicate that you are not setting your bond, that you are not to use or possess any alcohol, marijuana, or any illegal drugs. I'm going to indicate you're not to leave the state of Michigan without permission of the court. You understand that, sir?
Yes.
You're not to purchase or possess a firearm, ammunition, or other dangerous weapon or anything fashioned to be a weapon. You understand that?
Yes.
You understand you're not to assault, terrorize, frighten, intimidate, threaten, harass, or molest or stalk anyone. You understand that?
Yes.
I will also order that you're to have no contact with Lindsay Forbes except with a civil standby with the police. You understand that? You are also not to attempt to have any direct or indirect contact with that individual in person or through others, or by any electronic communication, including but not limited to phone, email, text, internet, or any social media. You understand that?
Yes.
I will also indicate you're not to go to the 3127 Scenic Lake Drive in Ann Arbor, Michigan, except with a civil standby with the police. That is not your home address. Is that correct, sir?
Yes.
I'm also going to indicate that you are not to violate any criminal law and you're to personally appear at all court hearings and other places as directed by the court. You understand that?
Yes.
Well, a couple of things, and I understand what the magistrate may have been taking into account in setting the original bond, but if there's no knowledge of a CSC pending, when you say that's going to be resolved, is it going to be resolved to your understanding by way of a plea?
Yes, there's a plea agreement.
Well, the court's concern is that the defendant was, Ms. Barosa, were you going to say something to the court or?
My understanding, Your Honor, is it's two counts of CSC first, one count of CSC second with a victim under 13, and then one count of child abuse and commercial activity. That was what was charged. I don't know of any resolution, but according to Oakland's website, there has not been a resolution entered yet, from what I can see. He just had a pre-trial on the 28th
Of
of May and is set for another pre-trial on the 11th.
more perplexing to the court is that the defendant was on bond on that case when this case allegedly occurs. That's a problem. And both being crimes of violence, that's a problem. I don't believe that the bond, the magistrate could not have known that other case that he was on bond on those other serious capital felonies at the time of the arraignment. And if she did know that at the time, the court would consider the setting of a personal cognizance bond to have been an abuse of discretion. So for those reasons, the court, in ordering everything that I've ordered, will set a monetary bond. In this case, his monetary bond will be set in the amount of $75,000 cash surety. Defendant's remanded. And as to the other matter, case ending in 0125, that case is dismissed. We have anything else ready?
I don't think so, Your Honor. I think the rest we have,
After what?
we're trying to work out.
You're trying to work out.
Yes.
What's that mean?
I would like to have another.
Never mind,
Okay.
never mind. I don't want your answer, Mr. Fairney. All right. Now, because it's gonna be close to the same, I'm not gonna like either one. All right, then I'll step off, and as soon as my staff lets me know that there's stuff ready for me to do, I'll come back on. All right, court is standing in recess.
All right.
Court does call the case, People versus Angel Wilson.
Assistant Public Defender Natalie Pate for Ms. Wilson, who is approaching. Please state your name for the record, ma'am.
Angel Wilson.
What are we doing?
Your Honor, there is a resolution in this matter to which Ms. Wilson will be pleading to added count 2 of operating while visibly impaired, and in exchange, count 1 will be dismissed.
Not operating while visibly impaired.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Angel Wilson.
Ma'am, it is this court's understanding you're gonna plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to $300 fine plus court costs. The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, order any rehabilitative services or community service the court deems necessary. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Yes?
Yes.
All right. You signed an advice of rights form today?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? August 7, 2023, at the location of US 23 near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much,
No.
what did you have? Tequila? Were you stopped by the police or was there an accident?
An accident.
What happened?
The car rolled over.
Pardon?
The
You need
car.
to speak up, young lady.
The car rolled over on the freeway.
All right. That didn't spontaneously happen. What did you do?
I lost control of the vehicle.
And you rolled it.
Yes.
Did the police and paramedics arrive? Were you taken to the hospital? Were you given a blood test? What were the results?
That I don't.
Was it 0.84?
The defense would stipulate to 0.84, Your Honor.
Do you have any reason to dispute those blood tests?
No.
Yes. No? Go ahead. Do you have any reason to dispute at all those blood test results? Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol? Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. I have another bond.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual Scram report from that company. I did discuss it in detail with Ms. Wilson. She does dispute both drinking and a tamper. She did provide me proof that she was at work as a CNA during that time. Further, both in the bond violation report I received from Scram, as well as my client confirmed, she received a new Scram tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new tether on May 28th. And then on May 31st, there was an alleged tamper that started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night. During that time, my client was at work from 6:54 a.m. to 3 p.m. She denies drinking
What
whatsoever.
time did the accident happen?
I'm sorry?
The offense, what time was she at work there at that point too?
So, Your Honor, it was at 4:20 a.m. was when law enforcement arrived on scene.
So early morning doesn't really matter, does it, counsel?
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so, go ahead, I'll let you go.
We would be requesting a formal hearing as to the bond violation. If the
Okay,
court
she'll
is-
get her hearing, but she's gonna be remanded pending that. I mean, I already have had a violation in this case.
I understand that, Your Honor, and I understand she was remanded and served 5 days for that back in. She denies alcohol use. Quite frankly, I do believe her, and I believe that this may be a malfunction with Scram. She did receive this new tether just on the 28th, and the 31st is when the alleged tamper occurred, and the alleged tamper ended at 10:39 p.m. at night. She still has the Scram tether on. There has been no further alleged tamper. Further, she has been to urgent care this week due to a medical issue that I won't go into too much detail with. I did provide a copy of the doctor's note that she received from that urgent care to Your Honor. We would respectfully request that if the court is leaning towards taking any action, that we set this for a bond violation hearing and that bond continue in the interim. She did enter a plea in this.
That would be fine, counsel, except for the fact that I'm now on my second violation, both involving alcohol. You want me to ignore the fact that the original incident was one where she was drinking, rolled a vehicle. She's lucky to be alive. Then I put her on this. She comes for this charge. She's drinking. She serves her time for drinking. I'm back and I now have another violation.
Yes, Your Honor.
How, in what responsible world would I let her bond just continue pending a year?
She denies alcohol use, and we believe it is a tether malfunction, and you're asking for a hearing on the matter. She did enter a plea for this underlying offense and the alleged incident, and she is willing to face penalties for that.
Yeah, because, well, give me the in custody sentencing dates, first of all. Changing your sentencing date, what?
June 25th at 9 a.m.
Sentencing will be June 25th, 2024 at 9 a.m. We will move that up. Got a time for a bond hearing I can do. The 25th, my bond hearing date. That's my date that I have planned, right?
The 25th is the sentencing. Yeah.
Well, but the 24th, we have trials and
Yes.
right? We'll set a bond hearing on this matter for June 24th, 2024, 9 a.m. Pending the hearing, will be set in the amount of 10,000, make it 5,000 cash. Days People versus Melissa Small.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Small. Ms. Small, please state your name. Melissa Small.
Morning.
Your Honor, we have come to a resolution. Ms. Small is going to plead no contest under 4A.
Is she signed this part? Okay, you got it.
solemnly swear and affirm the testimony about it will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Ma'am, it is this court's understanding you're gonna plead no contest to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, up to a $500 fine plus court cost. You understand that? You understand what a no contest plea is? You believe so? No contest plea means that you're not further wanting to contest this charge. You understand that? Verbalize your response. You understand that, ma'am?
Yes.
All right. You understand that I would review the police report and I would take those allegations that are contained in that police report, assume that they are true to determine whether or not a crime has been committed. You understand that? You understand also, ma'am, that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that? Now, with reference to that, is there any other questions that you may have regarding a no contest plea? All right. Counsel, the basis for the no contest plea.
Potential civil liability.
So ma'am, to the charge of domestic violence, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any questions regarding any of those rights? Please look at paragraph 5. Now, those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes.
and of your own free will.
Yes.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 244187. Any objection to the court reviewing that report?
People.
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 1. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 1st at 1 p.m.
July 1st, 2024, 1 p.m. All right. Bond with its conditions will continue. All right.
Thank you.
Ma'am, stop out at probation on your way out. Probation's on your left. Stop in there on your way out. Okay, just to check in with them and get your appointment. All right, thank you.
Public Defender Natalie Patewith, and on behalf of Mr. Howard, who stands to my right, please state your name for the record, sir.
Bilal Howard.
Thank you. All right, what are we doing?
An offer has been extended for the defendant to be discharged under a prosecutor's deferred.
All right. And he's gonna do a no contest plea, is that correct?
That is correct, Your Honor.
All right. Let's have him sworn.
Yes, thank you.
Raise your right hand. Do you solemnly swear in the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name. Howard.
Sir, it is this court's understanding that you're gonna enter no contest pleas to 2 charges, is that correct?
Correct.
The first charge is that of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
I do.
Count 2 is the charge of retail fraud in the 3rd degree. That is also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that?
I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about a no contest plea I need to make sure you understand is it first of all means that you're not further desirous or wanting to contest these charges. You understand that?
I understand.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
Understand basis for no contest plea.
Potential civil liability, Your Honor.
All right. So, sir, to the charge of assault and or assault and battery, how do you plead?
No contest.
The charge of retail fraud 3rd degree, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
I do.
All right, you signed an advice of rights form today.
Yes, I do.
Any questions regarding any of those rights?
No.
Look at paragraph 5, see it on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Understand?
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
and of your own free will?
Yes.
And the court has been provided and had the opportunity to review Pittsfield Township Department of Public Safety report for their case number 23-17281. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Yes, Your Honor.
Court will accept those pleas, 2 counts 1 and 2. Defendant is referred to probation for pre-sentence investigation and report and consideration of prosecutors deferred. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. Bond with its conditions. Sir, when you're walking, when you're on your way out, stop on the left-hand side. This is the probation department. Stop in there and check in with them so they can start the process for us. Okay.
All right.
All right. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Nicholas.
Assistant Public Defender Natalie Pate with on behalf of Mr. Militic, who stands to my right. Please state your name for the record, sir.
Nicholas Miller.
All right. What are we doing?
Your Honor, there has been an offer extended in this matter that if Mr. Militic were to plead no contest to added count 2 of retail fraud in the 3rd degree, the original charge of retail fraud in the 2nd degree would be dismissed.
That is correct.
Going to plead no contest to retail fraud 3rd.
Correct, Your Honor.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Nicholas Militich.
Okay. You can put your hand down. All right, sir, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the 3rd degree.
Correct.
Misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
All right. 2 things about it. Need to make sure you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
All right. Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand? You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes. Monroe County.
Probation.
Probation.
Were you on probation in 2023 and down there?
I was.
And in July?
Yes.
Okay. Now you understand then that this plea could be a violation of
Yeah.
probation.
Yeah.
Okay. If it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes.
Okay. And understanding that you still wish to plead to this charge?
Yes.
All right. Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-11203. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be July 10th, 2024, 9 a.m.
Thank you.
Thank you. Bond will continue. Thank you.
you,
Sir,
Your Honor.
on your way out, stop down and just say something to the probation department so we can get that started. Okay,
Yes.
thank you.
Thank you, Your Honor.
Thank you, sir.
Court does call the case of the people versus Brian Gonzalez Hernandez.
I apologize. Do I need to wait for the interpreter? I'm sorry.
Yes, we have an interpreter present. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment and to translate from English into Spanish, and from Spanish into English in the manner now before the court, so help you God?
I do.
State your name.
Kamal Hanawi.
Thank you. Well, all right. Go ahead.
Nicole Hughes on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Gonzalez Hernandez.
My understanding is he's waiving his right to a trial by jury.
That is correct, Your Honor, and we are asking for this to be set for a bench trial.
Sir, you understand that you have an absolute and constitutional right to have this matter tried before a jury?
Yes.
And you understand that by waiving that right, it will be tried before this court without a jury present?
Yes.
The people also waive their right?
Yes. Sorry. Yes, Your Honor.
Based upon the statement of counsel and defendant, the court will consent to have the matter tried before it without a jury. Non-jury trial will be set for June 24th, 2024, 9 a.m. Bond will continue. Thank you.
Thank you. Thank you, Your Honor. Would you like Mr. Gonzalez Hernandez to sign the waiver? Thank you.
Please. Thank you.
Thank you. Thank you, Your Honor.
Thank you, Mr.
Sir.
Thank you, Ms. Hughes, for stepping in. We ran a little bit long for Ms.
No
Barosa.
problem. Thank you so much.
All right, take care. Have a great weekend. That's it for us. 14A stands adjourned. People versus Delmore Brown.
Good afternoon, Your Honor. Nicole Hughes on behalf of the people.
All right, good afternoon. Ms. Barosa, you have a great weekend.
Afternoon, still afternoon. Assistant Public Defender Lauren Kearney on behalf of Mr. Brown's from take your name for the record.
Delmore Brown.
All right, the record should reflect we had a significant bench conference regarding this case, other pending matters that are kind of going along with it. And in that case, I think, given all of that, what the court's going to do is the court's going to adjourn this out to my next jury selection day. Miss, you had something you wanted to say?
Yes, Your Honor, I just want to put on the record, Mr. Brown is ready and able to try this case. He would like to try as quickly as possible. Would object to it being placed on that date. Again, we'd be ready to go.
All right. And the court is doing on its own motion. I note the objection of counsel that you expressed that objection very strenuously to the court in chambers, as well as to the prosecutor. I think it's in the best interest of this case and of justice to adjourn this matter out. So I'm going to adjourn this to August 9th, 2024 at 9 for jury final settlement conference. And then jury selection would be August 12th, 2024, 8:30. Those will be in person. Bond with its conditions will continue.
Thank you.
Sir, I'm gonna tell you what, check yourself. Check yourself as to how you leave this courtroom. I was watching you. You may leave now. Court calls case People versus Misty Perkins.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Perkins. State your name. We have come to some sort of resolution. Ms. Perkins, I have explained Ms. Perkins' constitutional right to a jury trial. She's going to waive her right to a jury trial and set this for bench. And Ms. Barroso and I are going to have continued conversations.
All right, very good. Ma'am, is that correct?
Yes, sir.
You understand that you have an absolute and constitutional right to have the matter tried before a jury.
Yes, sir.
You understand that by waiving that right, it'd be tried before this court without a jury present.
Yes, sir.
People also waive their right.
Yes, sir.
Based upon the statement of counsel, defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter would be set for,
June 24th at 9 a.m.
will that be enough time for you guys?
Yes, Your Honor.
I drive from Newaygo.
Pardon?
I drive all the way here from Newaygo, so it's like hard for me to get here.
Okay, but
If I gotta come, I gotta come. I'd rather come than go to jail, but.
what a concept. All right. Why don't I set it that date? I know people are trying to work some things, so let's try that date, okay?
Okay, thank you.
June 24th, 2024, 9 a.m.
Okay.
All right. Thank you, ma'am.
Thank you.
All right, drive safely, please.
Thank you.
Court calls the case, People versus Chelsea Graham. Oh, I'm on the record.
Okay.
I'm always on the record.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Graham. Yes, Ms. Graham called me or called my office this morning and we did make contact with her that she fell down her stairs and she's going to the ER. So that's the most recent information I have from her, Your Honor.
She signed into Zoom, did she not?
She signed into Zoom earlier this morning. Yes.
And we did inform her that she can't be present on Zoom. She must be here in person. And we told her that to send us any documentation of the ER visit, we would get that over to the court.
My favorite kind of case of driving while license suspended. Consider lifting it maybe when she sends something in, but I don't know why she was initially appearing here by Zoom. Bench warrant will issue for defendant's failure to appear. Bond will be set him at a $10,000 cash surety. That warrant will issue immediately. All right, so we can get that out of the way. Ms. Barroso, if we could have the waiver, please.
Assistant Prosecuting Attorney Morgan Barroso, on behalf of the people waive any potential conflict between this honorable court and the Public Defender's Office, so the people do not believe that such a conflict exists. The people make this waiver and avoid its any doubt.
Ms. Payne.
Assistant Public Defender Natalie Tate, on behalf of the Public Defender's Office, likewise, Your Honor, our office does not believe that conflict exists between our office. But if one so does, we waive.
All right, and the court for its part also does not believe there's a conflict either. The Michigan court rules or the case is decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of People versus Christopher Jones.
Assistant Prosecuting Attorney Morgan Barroso, on behalf of the people. Assistant Public Defender Natalie Tate, with and on behalf of Mr. Jones, who stands to my right, please state your name for the record, sir.
Thank you, sir. All right, what are we doing?
Your Honor, this is the date we have set for final settlement contract. At this time, we are unable to proceed. The defense would move for a dismissal.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you. Court calls the case People versus Linda Donald.
Prosecuting Attorney Morgan Barroso.
David I. Goldstein appearing on behalf of the defendant.
Here I am.
Yes, ma'am. Your name? Good morning. Your name?
Linda Donald.
Thank you.
This is the date we have set for final settlement conference, and the people are ready to proceed.
Your Honor, we are ready to proceed also. However, I
You guys
cannot,
are ruining my streak.
Judge.
But no, go ahead. That's
Hey,
fine.
don't look at me. She's the one that said it.
Yes.
Judge, I indicated to Ms. Barroso this morning that I have a conflict on Monday. I have a matter in Hillsdale County Circuit Court. So I am unable to proceed on Monday.
I have no objection to adjourning to August, Your Honor.
I think she probably has other cases.
Maybe. Very final settlement conference in this matter will be adjourned August 9th, 2024 at 9 a.m. Jury selection, if necessary, August 12th, 2024 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Court calls the case People versus Nafisa Ali, the Dari interpreter. Do we have a Dari interpreter present?
Yes.
Oh, she's here. All right, we do have a interpreter. Hold on. We have an interpreter present. May I have the interpreter sworn, please?
Right hand. You solemnly swear and affirm that you will interpret accurately, completely, impartially, using your best skill and judgment to translate from English into Dari and from Dari into English in the matter now before the court, so you got it.
I do.
State your name.
Gita Sohizat.
Morning.
Good morning.
All right, now, Mr. Sidler.
Conrad Siller on behalf of Pittsfield Township.
Go ahead.
Assistant Public Defender Natalie Pate on behalf of Ms. Ali.
Okay, what are we doing on this case? Okay,
It is my understanding that the prosecution is unable to proceed.
I am unable to secure the availability of the store witness, so we are unable to proceed at this time. We did have further discussion. Did you relay my concerns to your client?
Yes, I did. The defense would move for dismissal with the understanding that there is a potential this case could be reauthorized.
case is dismissed without prejudice. Thank you. That's called the case of the people versus John Zhang.
Prosecuting Attorney Morgan Rose on behalf of the people.
Hold on, we have a Mandarin interpreter. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment and to translate from English into Mandarin and from Mandarin into English in the matter now before the court, so help you God?
Yes.
State your name.
H Huang, spelled as H-E-J-U-H-U-A-N-G.
Good morning. Yes, go ahead, Ms. Verosa.
At this time, we are aware that this is the final settlement conference and we are unable to proceed.
目前来说，我们不知道这是最终的一个决定选择，审讯的那个方式，但是我们没法提供知识。
For the record, Assistant Public Defender Natalie Pate on behalf of Mr. Zhang, the defense would move for a dismissal.
为了记录原因，我的名字叫我的那个律师。我们要求把这个案件给驳回。
Case is dismissed without prejudice.
那这个案件就推荐。
Thank you.
Thank you, Your Honor.